Good evening, and thank you for joining me for tonight's webinar on estate planning essentials and ways to create your best estate plan. My name is Michelle Lianzo, and I am the estate planning attorney and an elder law attorney with Deloach Hofstra and Kavonis. And tonight we're going to be discussing ways to make your best estate plan. And the truth is, there's a lot of places you can receive information on creating your best estate plan. Of course, through the internet, neighbor, well-intentioned family members. But what we want to do tonight is kind of give you a good base for your estate planning knowledge and clear up any misconceptions you might have so you can make a clear estate plan for the future. I'm going to go over a little bit about what we'll discuss this evening. We're going to talk about what probate is and the best way to avoid it. We're also going to talk about wills versus trusts, what the difference is and why that matters. We're going to talk about how to avoid guardianship and the cost and the stress that that court process can bring upon your children or your loved ones. We're also going to talk about how to protect your money from the nursing home. And lastly, we're going to discuss how the proper planning really does make all the difference to your family, and it can truly provide you with valuable peace of mind. So what I'll say is, despite the level of knowledge that my clients have when they come in to discuss estate planning, they all have a lot of things in common. And that is, they generally want to take control of their estate plan, and they want to gain peace of mind. They want to plan for the unexpected, whether that's their incapacity or upon their passing. They want to make things easier for their family should they become incapacitated or at the time they pass away. A lot of them want to avoid probate. They want to avoid probate and guardianship fees and costs at those court procedures in court. And then they want to put a plan in place that will work not just at your death, but throughout your lifetime. And finally, they just want to be empowered through knowledge. They want to take a subject that they may know little or nothing about and make it make sense so that they can have the confidence going forward to know when problems occur, to know how to handle them. So we know that bad planning equals bad results. And it is common to feel uncomfortable when you're thinking about your death or your possible incapacity and how your family would handle that. And you likely don't want to cause your family undue money or undue stress, or spend all of the assets you've spent your whole lifetime accumulating should you need long-term care and spending that on the nursing home the last few weeks or months of your life. And at the end of the day, you don't know what you don't know, and that can cause you to act in kind of a paralysis. You don't know what the next step is, and it's scary, so you don't make a step at all. So we know estate planning isn't easy, and our firm has seen a lot of bad planning over the years. And bad planning can result in probate fees and costs for your loved ones. It can also result in much worse. It can result in litigation. And you don't want to create problems for your family should you become incapacitated or at your passing. They're going to be dealing with your grief. We want to make things as stress-free as possible. And you don't want to use all of your assets paying for the nursing home should you need long-term care. So I'm going to tell you a little bit about myself. I am a second career attorney. My first career was in real estate. And what I liked about real estate is what I love about being an estate planning attorney. And that was empowering clients through knowledge, taking a subject that they might feel overwhelmed about or not know a lot about, and making it make sense and giving them that confidence they need to go forward. And while I was in law school at Stetson Law, I found my way to the estate planning and elder law concentration. And a large reason I did that was because of my grandmother, who's pictured here on her wedding day to my grandfather. She was diagnosed with dementia when I was at Stetson. And it was that feeling of wanting to help, my family wanting to help, wanting to understand what was happening and what we could do as a family to support her, that led me to the estate planning and elder law concentration and why I love this course of law. I worked at another firm during law school and immediately after, but I found my way to Deloitte Hofstra and Kavonis in large part to work with one of the best elder law attorneys in Florida, Rep. Deloitte, and it's been an absolute wonderful experience and one of the best decisions I could have made. So I'll tell you a bit about the Deloitte Hofstra and Kavonis difference. We know that estate planning is more than good legal work or a transactional experience. It truly is the blending of three components, and that's going to be your assets, your goals, and good legal documents. All of those pieces need to be put together to make the best complete puzzle. And we're going to work as a team to achieve those goals. It's not lost on me that you're coming into my office and you're sharing personal things. You're talking about your family dynamic, or maybe you're speaking to me about a child with a disability or a beneficiary who's not good with money, who's irresponsible. I understand that, and we're going to have a journey of mutual trust and understanding what your needs are so we can accomplish those goals. So after our work is done, we want to be a continued resource. We want you to pick up the phone or shoot us an email if you have a question or a change in your plan or a concern. Our firm has been in business over 50 years, and a large part of that is because we focus on the client. We put the client first, and that has been true for generations of families. And our reviews and our feedback are a testament to that. So when we put out to do this webinar, we had a couple of reasons in mind. We want our clients to have peace of mind that we've helped their families as much as we could. We want to empower our clients through knowledge of their plan and knowledge of their documents. We want our clients to feel confident that they made the right decision when they're choosing who's going to act on their behalf for their financial decisions and their healthcare decisions. We also want clients to be able to protect their assets if they need to go into the nursing home. And lastly, we want to provide a process that serves our clients best. So how do we do that? How do we create a good estate plan? Well, again, we want to follow a process. It isn't just document preparation. We're not just putting your name into a already pre-planned document and spitting it back out. A good process is going to stand the test of time, and it's going to make sure that your wishes are followed, that things are easier for you and your heirs, and that you have good pre-planning for your long-term care, for your incapacity, and upon your death. And a good estate plan is following the steps of that process to make sure that you have a successful estate plan. So let's get into it. What are the steps of making a great estate plan? So first of all, we're going to look at your assets. That is step one. And there's 4 types of assets in your estate plan. These are individual silos. They all work independently of each other, and understanding those assets and how they work is a really key component to understanding your estate plan and which estate plan path works best. So the first siloed asset is going to be your probate estate assets. And these are assets like land, bank accounts, stocks, bonds, mutual funds. This is going to be any asset in your individual name at the time of your passing. Those assets, whether you have a last will and testament or not, are going to go through the probate in order to get to your heirs. The second silo is going to be jointly held assets. And these are assets that are held jointly with right of survivorship. So most commonly, maybe a checking account held with husband and wife. Husband passes away, the wife owns the checking account. There's no probate to make that happen. She's just the surviving owner. The third siloed asset are contract designation assets. And these are assets like life insurance, IRAs, 401ks, annuities. These are assets that you likely, when you initiated this asset, you designated a pay on death beneficiary. So those assets are going to go right to the named beneficiary upon your passing. The fourth silo are going to be trust assets. And this is going to be any asset in your revocable living trust. These assets are going to go directly to your trust beneficiaries without going through the probate process. So I'll explain a little bit about silos so you can understand how they interact or don't interact with each other. So Dad has 2 children, and the will says that his estate goes equally to his son and his daughter. But Dad has a falling out with the son, and he changes the will, disinherits the son. The last will and testament now says everything goes to my daughter. But Dad doesn't change the beneficiary of his IRA. In this case, when Dad dies, where does his IRA go? Well, we know that the IRA is a contract designation asset. So whatever is on that IRA designation, that's where the IRA is going to go. So if it says equally to my 2 children, that's where it's going to go. And this is a really good example on how the will does not control all of your assets, and that these assets all act individually. These silos act individually. So step 2. So we've looked at step 1. We've looked at your assets. Step 2 is looking at wills versus trusts and determining which is the better path. So what they teach you in law school is to write a lot of wills when you start out so that you can probate them later. And that's not an exaggeration, because wills do not avoid probate. A will is an instrument that states your intent, where you want your estate to go, but it doesn't avoid probate to get there. So how do we do it? How do we avoid the probate process? So first, we got to know what it is, right? Probate is the court process of making sure that your creditors are paid before your assets are distributed to your beneficiaries. So it's a court process. So that's going to involve filing fees and court costs. It's also going to involve hiring a probate attorney who's going to charge about 3% of the estate value. So already there's considerable cost involved in probate. And then there's time. Probate takes about 6 to 9 months if everything goes smoothly. And there's really not much you can do to speed that up. It's dictated by the Florida probate statutes. Those dictate a lot of the timeline. So you're talking about considerable money and considerable time. And why that time is going on, that estate is not dispersing. So those beneficiaries are likely getting a little bit frustrated, as is the personal representative of the estate. It's important to know that every estate plan doesn't need to avoid probate, but I will say that good estate plans generally avoid probate, and it is high on the list of things to avoid when clients come in to speak to me. So how do we do it? How do we avoid probate? One of the best ways to avoid probate is through a revocable living trust. It's also called a revocable living trust, inter vivos trust, all the same. So there's 3 roles in a revocable living trust. There's a settlor/grantor, a different name for the same thing. That's the creator of the trust, the person that's going to say, this is how my estate is dispersed. It's likely my client. Then there's the trustee of the trust, and that's the person who's going to manage the trust property. They're in charge of putting trust property in, taking trust property out. Initially, my client is the settlor and normally the trustee as well. And then the third role is the beneficiary, and those are the people or person who's going to receive the estate when the settlor or grantor pass away. So what's important to know with a revocable living trust is you control the assets during your lifetime as the trustee. There's no handcuff on those assets. You can interact with them the same way that you do today. Placing assets in the trust is called funding. Any asset in the trust is going to avoid probate. A revocable living trust is a probate avoidance tool. And so it's a really great way to avoid probate. So what are some other advantages? We know the trust avoids probate. It's also better coordination of an estate. You can have property in Florida and property in North Carolina or anywhere else in the United States, and you can put that into the trust pot or the trust bucket, if you will. You can also have other assets from anywhere in the United States. It has better incapacity planning. It does help prevent elder exploitation. It also can protect assets for your heirs upon your death. Another great aspect of trust is confidentiality. Unlike a will that is filed with the clerk when you pass away, a trust is not filed with the court unless something has gone horribly wrong. So the only people that see that trust upon your passing are the people named in the trust. There's also great beneficiary protection planning in a trust, and I'll go a little bit more in depth on that. So trust planning for beneficiaries. We have the ability to put remainder trusts or subtrusts, for lack of a better term, inside your revocable living trust that can account for irresponsible children. Maybe you don't want to give a child or a beneficiary a big lump sum upon your passing. Maybe you want to space that out over years or increments or whatever the case may be. And we have the ability to do that. Maybe you have a child with special needs. We want to make sure that what they receive from you doesn't make them lose their public benefits. So we have the ability to put language in there that protects them and allows them to benefit from their share of your estate. And we also have protection from a child's ex-spouse. Our estate plan doesn't just avoid probate, but we can put language in there to protect your child's inheritance from outsiders. So let's go to step 3. So step 1, of course, we're looking at your assets. And step 2, we're determining whether a will or a trust works best. In step 3, we're going to discuss funding your estate plan. And that is an intricate part. It's just as important as every other part of your estate plan, because there is nothing worse than someone coming in and maybe they have a trust and maybe they've had it for quite some time, 15, 20 years. And we ask them, what is in the trust? And they say, there's absolutely nothing in it. I did this trust. I didn't know how to fund it. I wasn't given the information I needed, and there's nothing in this trust at all. So for that reason, we're going to go in depth in the funding meeting. Once your documents are executed, we're going to go over each one of the assets that you've provided to us. And we're going to provide language and information on how to fund the trust, by meaning how to make sure that that asset is either titled to the trust or that asset is pouring into the trust upon your death. And we're going to make sure that you understand that. And then going forward, even after that meeting is done, we're going to be there if you need help. Or if you get another asset later on and you need to know how to get that into the trust as well. And the goal is to make sure that each silo goes to the right place. Each of those asset silos has a place to go upon your death. And we're going to work with you to make sure it's fully funded and make sure that your estate plan is complete. So I'm going to take a little sidebar now and talk about irrevocable trusts. And the reason I'm doing that is sometimes people confuse them with revocable trusts, or they're not quite sure how they work. So an irrevocable trust is used in much more limited circumstances than the revocable trust. So revocable trust protects assets from probate. Again, it's a probate avoidance tool. It is amendable and changeable, and you control the assets that go in or out. Then irrevocable trusts are different in that they are extremely difficult to change, and you are giving away a large portion of your control of a large portion of your assets during your lifetime. A lot of people don't like losing control of their assets. So for that reason, a revocable trust is used much more often. Irrevocable trusts are generally used to protect assets from the high cost of nursing home care. And when you're meeting with either myself or elder law attorney Rep. Deloach, those options will be discussed in detail, and we'll work with you to determine if it's an advisable solution to do an irrevocable trust. And the truth is there's several options when it comes to irrevocable trust, and each one has a specific purpose, specific timing, and specific parameters. So really meeting with an elder law attorney can help you determine which was best. Our website also does offer a free guide to irrevocable asset protection trusts, as well as being a wealth of information on other types of irrevocable trusts. So definitely use that as a resource as well. So back to estate planning. Let's talk about incapacity planning. So wills and trusts, we're of course focused on what happens when you pass away. But in addition to reflecting on your intent at your death, we want to discuss the documents that are going to assist you during your lifetime. And that's a durable power of attorney, a living will, and a designation of healthcare surrogate. And those documents allow you to name someone to act on your behalf when you're likely at your most vulnerable, when you're not able to advocate for yourself or act on your own. And understanding how these documents work allows you the knowledge and power to control what will happen during your incapacity and who will be your trusted person to step in and do that job. So I'll start with the durable power of attorney. So the durable power of attorney is effective as soon as you sign it. It is only valid during your lifetime. When you pass away, it is null and void. The durable power of attorney pierces all of those accounts and policies that are in your name only and allows your agent to interact and manage those assets. And it's likely, again, when you are at your most vulnerable. So having a trusted agent is essential. And we do spend a lot of time talking about that and who would be the best person to do that job. And we are really proud of our durable power of attorney. We are constantly making it better to make sure that your agent has the powers that they need and that you have peace of mind knowing that your finances would be in good hands, taken care of if you weren't able to. So how else does a durable power of attorney help? So I believe that durable power of attorney is possibly the most powerful document in the estate planning toolbox. It does help manage finances, pay bills. Your agent can even use it to do taxes, pick up your mail, things like that, the daily things that you do. But it also helps stop exploitation when you are vulnerable because you've got that trusted person in place to act on your behalf. It also helps avoid guardianship, the court process of guardianship, by being a less restrictive alternative. And that means a lot. Guardianship can cost upwards of $10,000. Again, it is a court process. You're going to be hiring an attorney to complete that process. So having this document in place is really, really valuable for that reason alone. It also helps protect assets from the nursing home, which is more expensive, right? That can be upwards of $10,000 a month. So having your agent help assist in sheltering your assets is a really, really valuable tool. So how do we do that? How does your durable power of attorney assist in Medicaid planning? So we know nursing home care is very expensive. It is, like we discussed, it can be $10,000 to $12,000 a month in Florida, and likely it's going to continue to rise. And the longer that we live, the more likely we're going to need long-term care. The truth is 73% of us will need long-term care before we die. And 50% of people over age 80 get some form of dementia. So those are staggering statistics, right? And will and trust planning does not protect the assets from the high cost of nursing home care. But our durable power of attorney will allow your agent the ability to work with our experienced elder law team, with Rep. Deloach and his team, to protect your assets. They're very well versed in the Medicaid process, Medicaid application, and making sure that you get good care, all the while allowing your agent to work with the team and shelter your assets. That alone does provide clients with really valuable peace of mind. So often when clients come in, they say, I want to know how to protect my assets from the nursing home with my estate plan. The durable power of attorney is going to be step one in that process, because likely you're going to need that when you're in some kind of a medical situation, you're not able to advocate for yourself. So naming a trusted person like your agent to be able to do the application, to work with your team and shelter your assets is a really important aspect of the durable power of attorney. And it is the first step when you're trying to see what you can do to help yourself in the future, to protect yourself and do some sort of Medicaid planning. So we'll also talk about estate taxes and your durable power of attorney. So they're also called death taxes. Some people might refer them as such, but right now your estate must be worth more than $13.6 million upon your death to incur an estate tax, and it is double that for a married couple. So I will say that's not a problem for the majority of our clients. But what if that changes? In 2026, that estate tax exemption is due to reduce in half. And in a perfect world, you'll come to us as that deadline approaches, and we'll discuss your estate plan and see if any changes need to be made. But what if you can't? What if something has happened and you're not able to act for yourself? Your durable power of attorney will allow your agent to make changes to your estate plan to help reduce or eliminate estate taxes. So what are the other advance directives? So there are living will, designation of healthcare surrogate. So the designation of healthcare surrogate allows you to name someone to act on your behalf if you're not able to communicate with your physician and make your healthcare decisions or consent or refuse consent for treatment. And the living will works hand in hand with that healthcare surrogate. It lets your healthcare surrogate know what are your wishes in the final stages of your life. Whether you want to be kept hooked up to machines, whether you want them to keep giving you basically prolonging measures. It does help, the living will does help let the surrogate know what you want and takes a little bit of the burden off of them directly. So we do furnish that document, and you're welcome to execute that along with the designation of healthcare surrogate. Then we go into step 4, and that's monitoring your plan. This is after your documents are executed. We don't want to just create the plan and hand you your documents, right? And just go about your way, because life happens. Your life is going to change. Your family may change. We have grandchildren born. Maybe your fiduciaries, the people you've named to act on your behalf, maybe they move away. Maybe your assets change. So when those things happen, of course, we want you to reach out and contact us, even if it's just a conversation over the phone, or you come in and we touch base and talk about how your plan may need to change. But additionally, the law could change, and you may not be aware of that. That's our job to know. So for this reason, if no changes, if everything's gone along and everything's copacetic, we would still recommend that every 5 years or so that you reach out to us. We can have a meeting by phone, Zoom, or in person. We just look at your plan and discuss any changes, and maybe you don't need anything at all, and we've at least just had a chance to touch base. But again, maybe the law has changed and you're not aware of that, and that might interact in some way with your estate plan, and changes can be made. So again, we would just suggest every 5 years or so that you reach out. So how does all of this help you? Why would you want to create your estate plan, right? We know that following the right process for your estate plan truly does give you peace of mind, knowing your affairs are in order. And I can tell you it's more often than not, when we've completed the signing ceremony, I have clients say they are so happy that this is done. They are relieved. Some of them literally have a sigh of relief when that happens. I think it's just a weight they don't realize that they carry until it's done and it's executed and their plan is in place. And not only is their plan in place, they understand the plan, right? So we'll have, again, your will and your trust will be secured. Your incapacity planning will be in place, which is a huge one. You can plan for the unforeseeable, for the unexpected. You have trusted people in place to advocate for you. Also, you and your family have a law firm that is there to help as life and the law changes. Again, we don't want things to stop once our work is concluded. If you have a concern, if you have a question, we want you to pick up the phone or send us an email so we can meet, or at least address the concern. We want to be a continued resource going forward. So I'll give you an example of our client, Charlotte. So Charlotte was 75 years old, and she was doing really well health-wise. And she had 3 children who actually really got along well. And she had assets around $800,000, not including her home. So for Charlotte, we set up a revocable trust to hold her assets, thus avoiding probate upon her death. And this saved the family at least $25,000. And that's huge. And now Charlotte has peace of mind. She can go on with her life, doing what matters most, knowing that her plan is in place, and her family knows where they can go if they have questions. So at this point, what do you need to do, right? Whether you already have documents, maybe from another state, or maybe they're from here and they're a little outdated, or you're starting from scratch, we want you to reach out to make an appointment. We're going to meet you where you are. You don't need to know anything about estate planning. If you do, that's great, but that's our job. It doesn't matter what the level of estate planning knowledge that you have. We want you to feel comfortable empowering yourself through knowledge. Maybe you've had a life event or prior experience that may have led you to watch the webinar this evening. I want you to call or email to set up your first appointment. And when you do so, we're going to provide you with a questionnaire to complete before our meeting. And it's going to ask you, of course, the basic questions, but it's also going to ask you about your assets. And I would encourage you to really fill that out to the best of your ability. It really does help to know which path we would suggest and just to make sure we put together the best estate plan possible. So I'll recap a little bit about what we've discussed. So far we've talked about what probate is and how it affects your estate plan. We've also talked about what assets go through probate upon your death. We've talked about how a revocable living trust puts your estate plan together and how truly good estate planning does lay the groundwork to protect assets from the nursing home. And finally, we've talked about the documents you need in addition to a living trust, those documents to assist you during your lifetime. So at this point, you have 3 choices on your estate plan. You can procrastinate longer about getting your estate plan done. I would say that that's a bad idea. Set aside whatever is delaying you and make an appointment. The second choice you have is doing things online without an attorney. And I will say that is a really bad idea because that's likely going to give you a false sense of security. And the worst time to find out that those documents are inadequate is when you need them most. If you care enough to do an estate plan, do a good one. The last choice is to work with a great law firm and to make sure that your goals are accomplished and your family is provided for. I'll explain a little bit about working with Deloach, Hofstra, & Kavonis. When you work with us, your estate plan is going to be done. Your trust is going to be properly funded. Your incapacity planning documents, the durable power of attorney, your healthcare surrogate, your living will are going to be done as well. You're going to be informed, you're going to be confident, and you're going to have a great firm as a resource going forward. So at this point, I want to discuss a little bit about your goals. So you took the time to watch the webinar tonight. So that it really is the first step in really recognizing that estate planning is important, or at the very least that you want to know more about estate planning. And it's important to know that not every estate plan needs a revocable living trust. We do will packages as well. But it's about recognizing your goals and what you want or you don't want to accomplish with your estate plan. So you may not care about the effects of your incapacity or if your family has to deal with probate going forward. You may not be concerned about having the best plan possible. Maybe it's not in your budget. But my hope is that you will realize what having a good estate plan will do. It will give you valuable peace of mind, and it will make things easier, a lot easier for your family, should you become incapacitated or upon your passing. So when you come into a meeting, we're going to have a 1-hour discussion and talk about your goals. And when you leave, you're going to know what estate planning documents will best assist you in accomplishing those goals. You're going to know what actions to take to accomplish the goals. You're also going to have peace of mind knowing that you've taken the first steps so that you and your loved ones will be better prepared for the challenges of tomorrow. And of course, you will have the Deloach, Hofstra, and Kavonis team to assist you along the way. So at this point, I want to go over some frequently asked questions. You're welcome to ask questions if you want, but sometimes people are a little hesitant in this forum. So I just wanted to go over some things that are frequently asked by clients. So people will often ask if a car goes into a trust. So no, we would not recommend doing that. If we avoid probate, cars are relatively easily transferred where they need to go upon your death. In addition, car insurance companies don't love that. So we would not recommend putting cars in a trust. A lot of people are concerned about their pets and making sure their pets are taken care of upon their passing. And we do have language that we can put in. It's called a pet trust, making sure that you've named a caretaker for your pet. And then you can also provide funds, provide money to the caretaker for providing for that pet upon your passing. And sometimes people are concerned if they move, do they need to change their documents? So your documents will be recognized wherever you go in the United States. I can say that when you're moving from out of state into Florida, it is always a really good idea to make sure you have Florida-friendly documents. When you're a resident of Florida, it just goes a lot smoother when you're using that durable power of attorney at the bank or the healthcare surrogate or whatever it may be. We would always recommend updating your documents to Florida documents. So we do have our flagship office, of course, in Seminole, Florida, in Pinellas County, and we also have an office in Sun City Center in Hillsborough County. You will receive an email containing ways to contact our office to set up an appointment, or you can call the numbers on the screen. You'll also receive a survey after the webinar, so please feel free to complete that as well. It's super helpful. And we also are a pet-friendly office, so feel free to bring your pet in when you come to speak to us. So I want to thank you for attending the webinar on estate planning. I truly do look forward to meeting you. I really hope that you'll make an appointment, whether it's on Zoom, over the phone, or in person. I appreciate your time, and I hope you all have a great evening. Thank you.